Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy, and today we're going to be addressing the First Amendment. This is what this filing in Idaho versus Koberger of May 11th, 2023, that was submitted by the media coalition, the Intervenors, replying to Mr. Koberger's filing, also dealing with the First Amendment earlier in the day of May 11th, 2023, specifically the gag order to the First Amendment freedoms. The media coalition here are pointing out that Mr. Koberger's objection to the intervener's motion to reconsider order dated May 4th, 2023, highlights the exact problem here. He requested and received a gag order without submitting supporting evidence to the court. He says he now has evidence to support his request for a gag order, but he needs time to put it together, even though a gag order has been in place for over 4 months. And he asked the court to continue to enforce a gag order while he collects that evidence. She then goes in, and this is Ms. Olson, lead counsel for the interveners, to talk about why this is improper, in her opinion. Mr. Koberger's request turns the judicial process on its head. When a party requests a court order, he has the burden of submitting the evidence that supports the order before the court issues the order. A party is not entitled to obtain relief first and then take months to collect and present evidence that purportedly supports the request for relief. And in my opinion, she is 100% correct here. Recall that when you're asking for an order in the form of a motion or whatever paper is submitted to the court, you're asking for an order to be entered. You're asking for some type of relief. And the party who's the movement of that paper 100% has the burden of showing to the court why it's proper for the court to enter that order as the party, the movement of that paper is asking for. She's arguing here that the cart's been put before the horse, that the order was entered without the supporting evidence Mr. Koberger was required to submit back in January 2023. Nonetheless, he got the gag order. She goes on to argue that while this is the general principle for orders overall, it is particularly significant when we're dealing with First Amendment rights, and a gag order that prevents a party from speaking about the case or the press from reporting about the case has to do 100% with the First Amendment. I agree with her. She says it's particularly important when the unsupported gag order here restricts First Amendment rights. And she cites to a federal district court in Idaho 2014 ruling, citing to a Ninth Circuit United States Appellate Court ruling 2012 that says the loss of First Amendment freedoms for even a minimal period of time unquestionably constitutes irreparable injury, and freedom of the press is one of the 5 freedoms, as is freedom of speech in the First Amendment. They go on to say interveners have suffered irreparable harm to their constitutional rights, that's the right, freedom of the press, since January. The judicial process, including the expectation that a party submits evidence before obtaining relief, particularly relief affecting another party, is designed to prevent that irreparable harm. So what she goes on to say is that for every minute that this gag order is in effect, there's continuing irreparable harm. If you'd like to take a look at this filing, I provided a link in the description to this podcast episode where you can get it. This is Kathy. Thank you for joining us here at the Indie Zone today.